On July 14, 2022, the Danish Data Protection Authority, Datatilsynet Danish DPA, issued a reprimand against Helsingor Municipality, imposing an immediate general ban on the use of Google Chromebooks and Google Workspace for education in primary schools. This decision was made due to the municipality's failure to document adequate risk assessments and reductions regarding the rights and freedoms of pupils, as required by the General Data Protection Regulation, GDPR. The Danish DPA's decision was based on the GDPR's requirements for data protection impact assessments, which mandate that data controllers, such as the municipality, evaluate and mitigate the risks associated with data processing. In this case, the Danish DPA found that the municipality had not fulfilled this obligation, leading to a breach of Article 35 of the GDPR. The ban, initially imposed until August 3, 2022, was subsequently ratified by the Danish DPA in a new decision on August 18, 2022. This decision reinforced the original ruling, emphasizing the need for the municipality to demonstrate compliance with the GDPR's data protection principles. Specifically, the Danish DPA required the municipality to assess and reduce the relevant risks to the rights and freedoms of pupils, as stipulated in Article 35 of the GDPR. The implications of this decision are significant, as it highlights the importance of data protection impact assessments in ensuring the compliance of data processing activities with the GDPR. The Danish DPA's decision serves as a precedent for other data protection authorities in the European Union, emphasizing the need for robust risk assessments and mitigation strategies to safeguard the rights and freedoms of data subjects. In the context of the GDPR, the Danish DPA's decision is noteworthy for its emphasis on the responsibility of data controllers to evaluate and mitigate the risks associated with data processing. The decision underscores the importance of data protection by design and by default, as enshrined in Article 25 of the GDPR. Marcelo Corrales Compagnucci, an associate professor at the Center for Advanced Studies in Biomedical Innovation Law, CEBIL, University of Copenhagen, provides an in-depth analysis of the Danish DPA's decision and its implications for data protection in the European Union. This draft paper is currently under peer review and is expected to be published in the European Data Protection Law Review, EDPL. No limitations or assumptions are explicitly stated in this section, but future work may involve exploring the broader implications of this decision for data protection in the European Union and the development of risk assessment methodologies that can effectively mitigate the risks associated with data processing. The Danish Data Protection Agency's DPA decision to ban the use of Google Chromebooks and Workspace in Helsingor Municipality is rooted in the General Data Protection Regulation, GDPR, principles, including lawful processing, transparency, accountability, and data controllers' responsibilities. The GDPR restricts the transfer of personal data to third countries or international organizations outside the European Economic Area, EEA, unless strict requirements are met. The Court of Justice of the European Union, CJEU, judgment in Schrems II and subsequent regulatory developments, such as the European Data Protection Board, EDPB, Recommendations 01/2020 and the new Standard Contractual Clauses, SCCs, for data transfer to third countries, were considered. The CJEU judgment in Schrems II led to regulatory developments, including the EDPB Recommendations 01/2020, which provide measures to supplement transfer tools and ensure compliance with the EU level of protection of personal data. The new SCCs for data transfer between the EU and non-EU countries were also adopted, providing a framework for data importers and exporters to ensure compliance with the GDPR. The GDPR outlines three mechanisms for transferring personal data to third countries: adequacy decisions, appropriate safeguards, and derogations. Adequacy decisions, as outlined in Article 45 GDPR, involve the European Commission determining whether a third country provides an adequate level of protection for personal data. Appropriate safeguards, as outlined in Article 46 GDPR, include standard contractual clauses, binding corporate rules, codes of conduct, certification mechanisms, and ad hoc contractual clauses. Derogations, as outlined in Article 49 GDPR, include consent and other exceptions. The Danish DPA decision is situated within this regulatory framework, and the article examines the origins and facts of the Danish DPA case, the reasoning and critical findings of the Danish DPA decision, and provides general recommendations for Danish municipalities in light of the decision's effects. The Schrems II case has significantly raised the bar for organizations seeking to comply with the complex legal landscape of data protection. By invalidating the EU-US Privacy Shield framework, the Court of Justice of the European Union, CJEU, ruled that U.S. law does not provide adequate protection under Article 45 of the General Data Protection Regulation, GDPR, as it fails to guarantee fundamental rights enshrined in Articles 7, 8, and 47 of the EU Charter of Fundamental Rights. This decision has created uncertainty among regulators, legal scholars, and data protection professionals, as it did not specify the required supplementary measures for GDPR-compliant transfers of personal data. Consequently, the original clarity of the GDPR has been undermined, necessitating new standard contractual clauses, SCCs, and supplementary measures to compensate for potential deficiencies in third-country law and practices. The pharmaceutical sector, where cross-border data transfers are crucial for research and development activities, has been particularly affected by the Schrems II decision. The judgment has profound implications, as organizations must now navigate the complexities of data protection and implement supplementary measures to ensure GDPR compliance. The European Data Protection Board, EDPB, recommendations and the new standard contractual clauses, SCCs, address the shortcomings of the Schrems II case, introducing significant improvements in safeguards for cross-border transfers of personal data. The EDPB proposes a six-step approach, emphasizing supplementary measures to ensure effective protection of personal data. Baseline core measures, as outlined in Article 32 of the General Data Protection Regulation, GDPR, include pseudonymization and encryption. However, these measures are insufficient on their own, and supplementary measures are necessary to ensure adequate protection. The EDPB identifies three effective supplementary measures: full encryption of transferred data, with keys solely under the control of the data exporter or an EEA-trusted entity, effective pseudonymization of transferred data, and reliance on split or multi-party computation. The EDPB also emphasizes the importance of assessing the third country's law and practice on a case-by-case basis to establish adequate protection of personal data. This requires a risk-based approach and a transfer impact assessment, TIA, evaluating risks associated with data transfer to a third country and identifying necessary mitigation measures. The EDPB recommendations and new SCCs introduce the obligation to assess the third country's law and practice, a significant innovation in data protection. This obligation requires organizations to carefully evaluate risks associated with cross-border transfers and implement effective measures to mitigate those risks. The EDPB provides guidance on effective supplementary measures, including encryption, pseudonymization, and split or multi-party computation. Collaboration between data exporters and importers is also crucial in ensuring adequate protection of personal data. Data exporters must work with data importers to assess risks and implement effective mitigation measures, reflecting a nuanced understanding of data protection complexities in the digital age. The EDPB recommendations and new SCCs provide a framework for ensuring adequate protection of personal data in cross-border transfers, emphasizing supplementary measures, risk-based approaches, and collaboration between data exporters and importers. This framework reflects a more robust approach to data protection, addressing the shortcomings of previous measures and providing a more effective safeguard for personal data. The European Union's General Data Protection Regulation, GDPR, Article 46 mechanism requires data importers to assess the legal system of the third country where data is being transferred to ensure the effectiveness of appropriate safeguards. This assessment involves evaluating aspects such as public authorities' lawful access to personal data. If the transfer impact analysis reveals that the Article 46 GDPR transfer tool is not effective, data exporters and importers must implement additional safeguards on a case-by-case basis to enhance data protection. A notable example of this requirement is the Danish Data Protection Authority's DPA decision regarding the use of Google Chromebooks and Workspace in Danish schools. The DPA had a pending case in Helsingor Municipality, where schools used Google Apps, later Google Chromebooks and Workspace, to grant students access to programs like Gmail and YouTube without parental knowledge, consent, and supervision. The G Suite software package, a Google product aimed at education, processed and displayed personal data such as names and school information. However, parents were not aware of this and did not have the opportunity to correct or anonymize this information, as only the municipality had access to user management panels. This scenario highlights the importance of assessing the legal system of the third country, in this case, the United States, where Google's servers are located, to ensure the effectiveness of appropriate safeguards. The Danish DPA's decision emphasizes the need for data exporters and importers to identify and implement additional safeguards to enhance data protection, particularly in the context of children's data. This is crucial, as the GDPR requires special protection for children's personal data, and the use of Google Chromebooks and Workspace in schools may not meet these requirements. In September 2021, the Danish Data Protection Agency, DPA, issued a decision requiring Helsingor Municipality to conduct a risk assessment and impact analysis of its processing activities involving Google Chromebooks and Workspace in primary schools. This decision followed a complaint from a parent whose child had created a YouTube account without their knowledge or consent, raising concerns about data protection. The Danish DPA found that Helsingor Municipality had failed to perform a risk assessment for the processing in question and had not implemented necessary technical and organizational measures to ensure adequate protection, considering the likelihood or severity of risks related to social media use with created school accounts. Despite the municipality's argument that the risk was low and unlikely to represent a risk to students' rights and freedoms, the Danish DPA concluded that an assessment was necessary. The Danish DPA also noted that Helsingor Municipality uses Google Cloud EMEA Limited as a data processor for its Google Chromebooks and Workspace usage. Consequently, the Danish DPA suspended any transfer of personal data to the US that Helsingor Municipality had instructed Google Cloud EMEA Limited to carry out as a data processor. This decision was based on the corrective powers given to supervisory authorities in Article 58(2)(d) of the General Data Protection Regulation, GDPR. The Danish DPA's decision emphasizes the importance of conducting thorough risk assessments and implementing appropriate technical and organizational measures to protect personal data, particularly in educational settings where students' data may be at risk. It also highlights the need for careful consideration of data transferred to third countries, such as the US, and the role of data processors in ensuring data protection. In Denmark, the Helsingor Municipality suspended data transfer to Google LLC in the US due to non-compliance with Chapter 5 of the General Data Protection Regulation, GDPR. To address this, the municipality implemented standard contractual clauses, SCCs, as a transfer basis and prepared a separate transfer impact assessment, TIA, following recommendations from the Danish Data Protection Authority and European Data Protection Board. The TIA assessed the risk of public authorities accessing personal data in the US, estimating it at 50%. Despite this, the municipality argued that this risk is more theoretical than practical, citing the low number of national security letter requests. However, despite implementing SCCs, the municipality acknowledged that personal data may still be transferred to Google LLC in the US as part of remote access for additional support services. The TIA revealed that personal data transferred to Google LLC in the US would be available in plain text, despite Google's use of multiple layers of encryption and pseudonymization. Google personnel can access the municipality's personal data since they hold the decryption key. This means that Google entities outside the EU, EEA or third countries can access the municipality's personal data with approval from the applicable Google entity established in the EU, namely Google Ireland. The municipality has ensured that personal data is only stored in data centers within the EU, EEA countries. However, this does not provide complete control over the access of personal data in the EU data center, as Google can still access the data with the necessary approvals. The TIA's findings highlight the complexities and challenges of ensuring GDPR compliance in international data transfers. The municipality of Helsingor conducted a risk assessment on using Google Workspace in schools, which involves data processing and transfer to the US for technical support. The Danish Data Protection Agency identified several violations of GDPR requirements, including inadequate security and protection for data transfers to third countries, particularly the US. Consequently, the agency banned such processing until it complies with GDPR. The key risks include processing personal data for other purposes, despite the data processing agreement with Google stating that data will not be used for other purposes. Furthermore, the agency raised concerns about the potential application of Section 702 FISA, although it is unlikely that personal data stored in EU data centers would be subject to this due to its exclusion from access under Section 702 FISA as a communication targeted to a US person. The Danish DPA's concerns highlight the importance of ensuring data protection and security measures are in place when transferring personal data to third countries, particularly the US. The agency's ban underscores the need for compliance with GDPR requirements to ensure the privacy and security of personal data. In the context of personal data processing, Helsingor Municipality conducted a risk assessment on the use of Google Workspace in schools. This assessment highlighted potential risks associated with data processing, particularly the possibility that Google might breach contractual obligations and utilize personal data for marketing or other unintended purposes, violating the municipality's instructions. This risk is especially concerning as it involves personal data related to students, who are entitled to special protection under data protection regulations. The risk assessment identified contact information, IP addresses, and digital traces as relevant data types, with their processing being an additional element in the risk assessment. Furthermore, the risk of transferring personal data to third countries without a necessary transfer basis and without assurance of similar data protection rights as in EU countries was also noted. Despite the municipality's efforts to map personal data usage in schools, the Danish Data Protection Authority, DPA, concluded that the municipality had infringed upon several articles of the General Data Protection Regulation, GDPR, including Articles 5, 2, 5, 1a, 24, 28, 1, 35, 1, and 44, as well as 46, 1. The DPA determined that the municipality had not successfully assessed specific risks related to the data processing construction and processing activities as a public authority. The risk assessment was criticized for not covering all possible risk scenarios arising from the data processor design and system choices. Additionally, the municipality did not conduct sufficient testing of the scope and operation of the selected systems. Consequently, the Danish DPA imposed a ban on the use of Google Workspace in the municipality, emphasizing the importance of robust risk assessments and data protection measures in the context of personal data processing. The Danish Data Protection Authority, Datatilsynet, has rendered a decision on the use of Google Chromebooks and Workspace in Helsingor Municipality's schools, citing non-compliance with the General Data Protection Regulation. The authority identified three key areas of concern: inadequate data protection impact assessments, failure to ensure data minimization, and insufficient safeguards for cross-border data transfers to the United States. Regarding data protection impact assessments, the Danish DPA emphasized that a thorough evaluation is mandatory under Article 35 of the GDPR. The municipality failed to properly assess the risks associated with Google Chromebooks and Workspace, nor did it evaluate the necessity and proportionality of the data processing activities. The Danish DPA also found that the municipality did not ensure data minimization as required by Article 5, 1c, of the GDPR. Google was permitted to collect and process personal data that was not strictly necessary for the provision of educational services. Furthermore, the Danish DPA addressed the issue of cross-border data transfers to the United States, relying on standard contractual clauses. However, the authority argued that this may not be sufficient given the potential risks to data subjects' rights and freedoms, particularly in light of the Schrems II judgment. The municipality's reliance on encryption as an additional safeguard was also deemed insufficient, as Google LLC could still access the information in plain text. The Danish DPA's decision highlights the importance of conducting thorough data protection impact assessments, ensuring data minimization, and implementing robust safeguards for cross-border data transfers. The authority's ruling upholds the ban on the use of Google Chromebooks and Workspace in Helsingor Municipality's schools, emphasizing the need for compliance with GDPR requirements. The Danish Data Protection Authority's decision on Helsingor Municipality's use of Google's technology for processing personal data of minors highlights critical issues. Despite claims of mitigating risks, the authority argues that the municipality failed to assess inherent contract risks and publicly known risks associated with Google's technology. The municipality's identified risks were also insufficiently mitigated. A key point of contention is Google's role in the data processing pipeline. The municipality views Google as a mere data processor, while the authority believes Google acts as an independent data controller, processing personal data for its own purposes. This distinction has significant implications for data protection and privacy. The case is complex due to the involvement of personal data from minors, which poses risks including embarrassing content, exposure to inappropriate material, libel, sexual harassment, and cyberbullying. The authority emphasizes prompt correction and deletion of personal data, requiring the municipality to contact parents of registered pupils to implement corrections, anonymization, or deletion of personal data. This decision has far-reaching implications for other municipalities using similar Google tools, particularly regarding unauthorized disclosure and transfer to unsafe third countries. Municipalities must take action, assessing whether similar problems exist and implementing corrective measures to manage legal risks. Compliance may be costly and burdensome, but it is essential for ensuring personal data protection. The Danish Data Protection Authority continues to prohibit the use of Chromebooks in schools, citing concerns about data privacy and compliance with the General Data Protection Regulation, GDPR. In response to practical challenges following Schrems, Danish municipalities are advised to conduct a transfer impact assessment, TIA, to establish that data transfers are not subject to FISA 702 or other problematic legislation. This approach aligns with the privacy by design and by default principle. Furthermore, investing in risk assessment software tools could be beneficial for enhancing compliance efforts. However, it is crucial to note that contractual and organizational measures alone are insufficient. Technical measures such as full encryption, pseudonymization, and split processing offer more effective supplementary measures, particularly when utilizing cloud computing services. These measures are essential for ensuring data privacy and GDPR compliance in the context of digital education tools. In the realm of data protection, a promising solution to address the limitations of municipalities in ensuring secure data processing and transfer is the utilization of technical solutions such as multi-party homomorphic encryption. This method combines secure multi-party computation, allowing for the querying and analysis of encrypted data without the necessity of decryption. Consequently, it enables municipalities to implement scalable and effective data protection measures that can be adapted to their respective limitations. Another alternative is the exploration of emerging technology-driven solutions, which enable organizations to store data in the end-user's personal cloud. This approach follows the user-held data model, granting individuals greater control over their data and providing more value from it. A significant advantage of this approach is that it significantly reduces the need for unnecessary open-ended cross-border data transfers, as users could choose their geographic location and keep their data stored locally within the EEA in a more decentralized manner. The research for this paper was supported by a Novo Nordisk Foundation grant for a scientifically independent collaborative research program in biomedical innovation law. The authors acknowledge the support of this grant in their research efforts.